This is the Morning Crossfire on 92.3 Nigeria Info.
Welcome back. It's Morning Crossfire 92.3 Nigeria Info. My name is Sam Chinedu. For this hour, we're looking at prison congestion. River State government in court to set aside the judgment of a high court releasing 150 prisoners from Port Harcourt Correctional Center. Recall that last year in December, a state high court delivered judgment releasing 150 inmates after they spent more than 8 to 9 years without appearing in court since they were remanded. When the matter came up before Justice Gio Olo, it was of course adjourned to February 24 to enable the lawyer to the state government file his further application. Lawyer to River State government shortly after the court proceedings explained why they want the court to stay the execution of the judgment.
Most of these 150 persons listed, they actually have ongoing criminal trials in other high courts. And if the court had known about this, the court wouldn't have made the order, because ordinarily this court has no power to terminate ongoing criminal proceedings in other high courts. Only the Court of Appeal can do that. That is why we brought an application to the court, asking the court to set aside that order, because it did not have the benefit of all the facts of the matter. They knew that they were facing trial. Possibly they even suppressed these facts from their own lawyer. It is very likely the court wouldn't have given that judgment. That is why we are back here. The law allows us to come back to the court.
Now, in the meantime, Nasiru Ibiloye, lawyer to the inmates, in an interview with our correspondent, explained the grounds the court can only set aside the judgment it had delivered.
The Attorney General brought an application to stay execution of the order of the court to release those inmates, and also brought an application to set aside the judgment made by the court. We have responded to that affidavit by filing the counter affidavit allowed by the law. No, the court has the power to set aside its own judgment on certain grounds. Fraud, essentially, and on issue that the court does not have jurisdiction to hear the matter. Apart from that, we are not envisaging any other ground for the court to set the order.
All right, Nasiru Ibiloye, of course, the lawyer to the inmates joins me this morning. Good morning, sir.
Good morning.
Thank you very much for joining us.
Yeah.
All right, so tell us the intricacies of this particular case. 150 inmates awaiting trial, 8 to 9 years released, but the court is saying no, that's not something they want to do. Why exactly, and how did we get here?
Okay. I visit a prison regularly.
Okay.
On this day, I went to the prison and discovered that the awaiting inmates are more than the convicted prisoners already. Port Harcourt prison has a capacity of 803. But when I look at the list, they have over 4,000. So I inquire, and I was told that the awaiting trials I made it very high, because the main convicts are no more than 300. I was worried. So I took up, I started inquiring, because we have an NGO called Access to Freedom International.
Okay.
Our sole aim is to assist indigent Nigeria to get access to freedom, as well as advocating for a better welfare for prisons across the country. So I took up this challenge, got a list from the prisoners to know, I asked the prison warders to know why the numbers are so increased. So they told me that they gave me a list. I went through the list, made an application to the Chief Registrar of the River State High Court to give us the list of, to give us the charge sheet of the awaiting trial inmates.
Okay.
It took us time. We could not get that list. We had to file and enforce their right in the High Court under the Fundamental Human Rights Rules that give us the right to enforce rights of a class of people who rights we feel has been breached. We went to, we filed that matter, now joined the Chief Registrar in the matter, and got an order from court compelling the Chief Registrar of the River State High Court to supply us the particulars. Eventually, we got the particulars, serve everybody that is concerned, because we sue the Commissioner of Police, the Attorney General, we sue the prison controller, and of course the Chief Registrar joined in the suit by the application, by the order of the court. The Attorney General entered appearance for all these parties, filed a process, and never brought any documents to show that any of the awaited trial inmates is standing a trial in any court. Up to today, we have not even had the opportunity of getting a document from the Attorney General's office to tell us one court where any of those 150 awaited trials inmates are standing trial. Eventually, the matter, they filed their own papers, we filed our own, and the court took a position and ruled on the matter on the 16th day of December 2020. We were surprised that the general brought an application. One, is their right to bring an application, but to set aside the order of the court. I don't see how that can be possible, because the only way an order of the court can be set aside is when there's a fraud, like I've said earlier, when there's a fraud and the court does not have jurisdiction. The High Court has jurisdiction to try this matter. There's not the order of the High Court that was eventually given on the 16th day of December was done after every party has participated. The processes have been filed, documents considered, and the court came with a ruling. That cannot be an element of fraud anyway. So I'm here to know the ground a court will hold in setting aside this order he has made, except on appeal. The Court of Appeal has the power to do that. Whatever they are saying now, that the people are standing trial, is an afterthought. I'm sure that there's nothing like that. They've not done their work, and they're looking for a means to cover what they have not done. Justice is for all parties. A man who will say he has committed an offense and has been in custody for almost 14 years in some cases should have started his trial. Maybe he will be found not guilty, and the man will go home. For keeping the man in prison, is the prison a dumping ground? I've asked that question several times, and they will not be able to answer me. The prison is not a dumping ground. The facility, the prison are stressed. If you know you'll be putting people in prison, go and get another facility for waiting trials inmates. The prison facilities are stressed with this number. The number is increasing every day, and the reason for the increase of the number is because somebody is not doing his work. If somebody is doing his work, these numbers will not increase to that amount.
All right, Barrister Nasiru, we've gotten a background. Now, stating that it's an afterthought.
Yes.
Of course, what they said, that's your opinion. It's not a statement of fact. That's what you think.
Yes.
Yeah, but of course, they came up with what they believe is the reason for taking that decision. So what I've gotten from what you've said is they have no power to set aside a judgment, and there was no proof to show that those inmates were being tried.
Yes.
Those are the two most important things.
Yes. Even with this, the application they brought now, they've not able to point at one court, justice this or justice that, and what any of the inmates are standing trial for. No one document has not been annexed to any application they brought till date.
So what is your organization pushing for? For those inmates to be tried or released?
Now they have overstayed. They should be released if they cannot be tried. Because, as I said, justice delay is justice denied. Those people have been denied justice. And the Administration of Criminal Justice accept. When somebody is not prosecuted in 1 year, the person should be discharged.
In 1 year?
Yes, 1 year.
That actually exists?
Yes, it exists. It's in the rules.
In 1 year?
Yeah, 1 year. If no prior is taken against the person, it should be discharged.
And you're sure that part of this code is visible to everybody who is supposed to know? Because the Nigeria and the prison system, I know, goes completely against that particular code.
Now, let me tell you something about the prison. Why the prison population is increasing. Somebody is not doing this work. The police will arrest you. You found guilty or you're not found, you're arrested as a suspect. And the suspect is taken to a magistrate court after the investigation. And when it's taken to a magistrate court, in the magistrate court, it's called like a holding charge, which is even illegal. The magistrate court has no power to try the man, but the magistrate has the power to remand the man.
Okay.
Now, the man is remanded in prisoner custody. This is our own findings. And the file is sent to the DPP for legal advice, which sometimes, in most cases, 90% of cases, never comes at all. The DPP advice will not come. The man is languishing in prison, is there. Woe betide the man. There's a turn in a date, maybe a Muslim holiday that just comes, and the man does not get a date, maybe his date fall on one of those dates. That is the reason why the man will remain there, because he might not get another date and he will just be there. Most people who are in prison, the population of prisoners today are one of those people who have those kind of circumstances. They will be in prison, no date, no court, they'll just be there. And this is prison, on a daily basis, they are sending people to that prison. The population that comes out are more than the population that goes in.
Unless.
So, people that comes out are less than those, comes out are less than those who goes in. The number that goes in every day are much. Now, those people are hanging in prison. No trial for them. And it relates to this 150 inmate. I challenge the River State Attorney General to produce those documents. If you come to the studio and tell us and produce those documents, then I'll be satisfied.
So
today,
the inaction of the DPP is obviously escalating this problem.
Yes. I'm telling frankly, yes. The DPP, I'm bold to say here, are not doing their job. If they are doing their job, we have convicts, not awaiting trial inmates.
Okay.
The awaiting trial inmate thing is even degraded, because when the prison facilities are stretched, you see people are packed in a room because the facility, the warders cannot do magic. So if they want to be dumping people in the prison, they should build another prison where awaiting trial inmates can always be, and that will solve most of this problem, because everybody needs to be treated decently.
How are you able to get the list of this 150 and tell that they had been there for a minimum of 8 years?
Okay. This is our NGO. Prison welfare is one of our hallmark. So what we did is that one day I went to the prison and I asked them, do you have a library in this prison? It was a concern. And they said, no, they don't have a library. And they showed me one rickety thing at the welfare department. So I looked at it and I said, how can you take a car to the mechanic workshop and you are bringing it worse than you took it there? That the prisoners, you should have provided a library for them. They will read, and as they are coming out, they will come out as changed men.
To rehabilitate.
Yes. So what happened is that I now applied. I said, okay, I want to build a prison, a library in the prison.
Okay.
So it took a while, but at the end of the day, it was approved. I had to go to Abuja to get that approval.
When you say while, how long are we talking?
Almost 2 years.
Okay.
After getting the approval, the space they gave to me was full of debt. They said I must remove those debt. I said no problem. I took a tipper, went to the prison yard and removed them. I know prison is a very conventional place. You don't take a big tipper there, you must take a smaller tipper and things like that. Eventually, we started the project.
Okay.
We started building. You cannot take a worker outside the prison yard. So you get prisoners. So in the course of them working, I interacted with them. How long have you been here? They will tell me, which court is your matter? I say, it does not have a court. So I was curious. I said, this number of people don't have a court. Is it applicable to everybody? Because I had access now. Because I was doing a project in prison. I had access to go in and come out of prison. So I asked, and I was curious. I was worried. I said, how do you manage? And they tell me the facility here is overstretched. I even had to do a toilet for them. One toilet, I had to buy toilet bowl and things like that to repair one of their toilets. And that people are arranged like the slave trade era, where they are arranged like like sardine. I said, what is happening in this country? But the government said it's spending so much money on the prison. So
Wait, hold on, Barrister.
Okay.
You didn't know this. I'm not a lawyer, and I know what people in prison. I know the conditions. For you to be that shocked, I'm shocked that you were shocked.
No, I was shocked because I have gone into the prison. I'm sure you have not visited there before.
I visited someone.
Okay, me, I went inside because I was doing a project there.
No, I've not been inside. Yeah.
So I saw those things and I said, okay. I went to the prison. I said, okay, give me the list of these affected inmates. And I was able to get even more than 150.
I'll take that again. You told who to give you the list?
Yes, I went to the welfare department.
Welfare.
Yes.
Okay.
And I applied for the list. That they should give me the list of the awaiting trial inmates.
Okay.
And those who are especially affected with this kind of condition. They gave me the list. I went through the list was huge. I started analyzing the list myself. And at the end of the day, I applied. I want to be sure, so I applied to the court. I said, okay, give me the certified true copy of the charge sheet, which is a public document. Give them to me, let me look at them and study them. When I do that, it will give me, I will look
An
at
idea of the kind of offense.
the kind of offense they have committed.
Yeah.
Do you know I applied and never got one? They said they cannot find them.
They cannot find
They
them.
cannot find them. I never got one. Out of that frustration, I said, okay, I will do something. I applied for their fundamental human right, which is my right to do under the new fundamental human right rules. I can bring a fundamental human right action against a class of people. So for a class of people, sorry, not against them, for a class of people, against those who I feel are oppressing them.
Abusing them, yeah.
Yes. So I took up this thing and went to court. So when I got to court started asking, well, okay, where are the documents? You say you applied. Did you get them? I said, no, I don't get them. So it occurred to me to join the chief registrar in the matter.
What
So
court?
Justice Olo's court is now sitting at Oyigbo. It was court 23 then.
Okay.
So I joined the chief registrar in the matter and said, okay, the court can make an order compelling her to release it to us. Since it was hard for them through our own application, the court made an order, joining the chief registrar in the matter and making an order for her to release those documents. Eventually, those documents came. Not all of them. We got about 130 something of the charge sheet. Only charge sheet to today. We never got any advice from anywhere. And these charges, these offenses I'm telling you, are the offenses that the magistrate court cannot try. They are capital offenses. Till today, we didn't get an information from the Attorney General.
So the action of the DPP was obviously hanging.
I don't know.
You said no advice. Charge sheet, there was no advice.
No. We got the charge sheet.
Okay.
The chief registrar eventually brought the charge sheet. But we did not get one single advice from the DPP.
Yeah.
Or an information, an information in the High Court that has jurisdiction to try that matter.
For all 130.
For all the 150 inmates. We got 132 of the charge sheet in the magistrate court.
Yeah, okay.
Which I told you earlier that is an illegal thing.
Yeah.
But we could not get an advice or an information in the High Court for any of the inmates. We served the DPP, we served the Attorney General. A lawyer appeared. The lawyer has been elevated. He's a judge now. Dr. Bassam. He's a High Court judge now. He appeared. The matter was even adjourned severally at their instance. They will come, they will say one or two things, the court will adjourn the matter. Eventually, the matter was heard this year. The matter was filed since 2018. It's a fundamental human rights rules matter. It's supposed to be for a short period of time, according to the rules. But this matter, from 2018 to 2020, when judgment was given, the Attorney General or DPP never brought any document. And so, okay, there's an information in the court, apart from the charge sheet we have. No information, not it today. The court eventually looked at the whole matter and ruled that those people's, the 150 inmates' right have been breached, which is the right thing for the court to do. If the court made that declaration, it's after he has heard from me and the Attorney General, before the court made that declaration. The court made the declaration and ruled at the end of the day The Attorney General now brought this application they are bringing, which I feel is frivolous. I'm telling you, it will be a judicial, it will be a mess to the judiciary. If any court can grant that kind of application, you participated in the matter with me, you were there, you participated fully, you were given opportunity to bring all the documents you need to bring. It never brought anything. Only for you to wake up in the morning and say that the court should set aside and start this matter again. It has never been done before.
No, Barrister Ibiloye, in
Yes.
football, that's what they call extra time.
There's no extra time in this one.
Oh, really?
Yes, what the court has held us as rude. That's why they will have the constitution that said you have a right of appeal, which they've appealed. Oh, they've appealed on this matter. Despite the appeal, they brought all these frivolous applications. I'm telling you it's frivolous because I'm a lawyer and I know my honors. They are frivolous. They will not see the light of the day. Okay. We are talking about the rights of citizens of this country. You have heard them for this number of years. And you are bringing this kind of application to see, for that hold them. And the only reason they converse in their application is that these people are criminals. When they come out, they are going to disturb the security of the state. Can you imagine that? Can you imagine that somebody you are held for a number of years, instead of you to be apologizing as the constitution required, you are saying that the man will come, is a criminal. And that when he comes, their presence will affect the society. That's the only reason they've conversed.
My initial concern when I heard of this case was if any of them were actually apprehended for a crime
Yes.
that deserved a particular time,
Yes.
and you checked from minimum of 8 years and above,
Yes.
and if this person had not served that particular time, it would be taking them out too early. But the fact that they never made it to court is another conversation completely.
Yes.
Because if I'm supposed to serve, say, 10, 15, 20 years,
Yes.
I've been there for 8 years.
Yes.
Your intervention comes,
Yes.
and somehow I am out.
Yes.
If I made it to court, I'm still supposed to be in prison.
Yes.
Do you understand what I'm saying?
Yes.
Ensuring that the offense kind of tallies with the time. But the problem is they never made it to court. So that's the biggest problem.
Now, I want to give you an instance.
Go ahead.
In 2016, like in one of those my visits to the prison, I was able to meet some group of people who committed a case of stealing.
Stealing.
Yes, and they've been in prison for 5 years.
What did they steal?
No, case of stealing. I don't know what they stole, but that's the offense against them.
Yeah.
And they've been in prison for 5 years. I asked the question, if this man is convicted by the prison calendar, he'll be spending 2 years. What's he doing for 5 years? So I took up that challenge by myself before Justice Enabili, and I took that challenge. I went to court in my name for the 25 inmates. That was our starting point. That was 2016. The court looked at it and said, made a declaration that their right has been breached. And the court now released them on bail, to go on bail. Now, if these people were convicted for stealing, like I told you, they were spending 2 years by the prison calendar. The law said that the maximum they can get is 3 years. That means they won't get up to that 3 years. But this man has been in prison for physical 5 years.
Let me get something clear.
Yes. Now, I want to go back to those awaiting trial inmates.
Yeah.
Those people are suspects. The suspect means that they are suspect. They might be found not guilty, or they might be found guilty.
Yeah.
Now, to say they've not stand up to the period of period required for that kind of offense.
If found guilty.
If found guilty,
Yeah.
it's not material at this time. What is material is that these people have overstayed in prison without trial. They are innocent by the law. They are presumed innocent by the Constitution of the Federal Republic of Nigeria.
Until proven otherwise.
Yes, to prove otherwise.
Yeah.
So if this man is spending that kind of number of time in the prison custody without trial, and I say that, okay, if we found guilty of that offense, that is a material for now. What have you been waiting for? That you want him to spend all the years for the same offense? That at the end of the day, if he's found not guilty, what will happen to him? What about the numbers of years he has spent in his life? He cannot get that back again.
Truly.
Yes.
I'd like to know how the justice system works at this point.
Okay.
And the answers I need is what is applicable right now and what the law provides. If somebody's awaiting trial for, say, 5 years,
Yes.
eventually gets to court and is found guilty,
Yes.
and maybe they've been sentenced to 10 years,
Yes.
does the 5 they've spent count towards the 10 years they get, or they have to start afresh? How does it work?
It's a waiting trial. It does not count. It's a waiting trial, except the court is magnanimous enough to say, okay, I will spend 5 years. I'm sentencing you for 10 years. Let the period start reading from when you went to prison, where you were remanded in prison.
Okay.
That's fair enough. It's at the discretion of the judge to do that.
So it's based on the mood and the goodwill of the judge.
Or the judge
that
to do that.
could happen.
Yes.
But
So that-
besides that, he's going to get 15 years.
It's going to be 15 years, and the man will start the whole 15 years. Aside from the time you have spent awaiting trial, like the name is awaiting trial.
Okay.
It's not a convict. A convict will start, his time will start running. But awaiting trial time does not run. It's awaiting trial. It's kept there, it kept in custody to await his trial.
Has there been any recorded case of someone who was awaiting trial, eventually found innocent, released, and compensated? Have we had compensations?
Now, what I went to court to do is to enforce their right. I didn't go to court to stop the DPP to prosecute them. Now, as their right be breached, the answer, my own opinion, is yes. And the court has confirmed it by declaring that the right has been breached. That does not stop anybody from being prosecuted.
Okay.
But now, are you supposed to prosecute him after 8 years? Are you supposed to prosecute him after 100 years? The question is that their right has been breached, and they must be compensated for those rights.
All right, it's the Morning Crossfire 92.3 Nigeria Info Conversations with Nasiru Ibiloye. He's a legal practitioner. And of course, following the conversation, you get the picture that is being painted. After the break, we discuss whose duty it is to go check prisons to check out how many awaiting trial humans are there. Don't go anywhere.
The Morning Crossfire.
Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817 001 8162. That is 0817 001 8162. And let us connect you to your customers.
We crossfire in the morning. Crossfire in the morning. Get into the midday dialogue and tell you about the hard facts, and then let's talk into the chat station. All for you on 92.3 Nigeria Info. We crossfire in the morning. Crossfire in the morning. Get into the midday dialogue and tell you about the hard facts, and then let's talk into the chat station. All for you on 92.3 Nigeria Info. We crossfire in the morning. Crossfire in the morning. Get into the midday dialogue and tell you about the hard facts, and then let's talk into the chat station. All for you on 92.3 Nigeria Info. We crossfire in the morning. Crossfire in the morning. Get into the midday dialogue and tell you about the hard facts, and then let's talk into the chat station. All for you on 92.3 Nigeria Info. We crossfire in the morning. Crossfire in the morning. Get into the midday dialogue and tell you about the hard facts, and then let's talk into the chat station. All for you on 92.3 Nigeria Info. We crossfire in the morning. Crossfire in the morning. Get into the midday dialogue and tell you about the hard facts, and then let's talk into the chat station. All for you on 92.3 Nigeria Info. We crossfire in the morning. Crossfire in the morning. Get into the midday dialogue and tell you about the hard facts, and then let's talk into the chat station. All for you on 92.3 Nigeria Info. We crossfire in the morning. Crossfire in the morning. Get into the midday dialogue and tell you about the hard facts, and then let's talk into the chat station. All for you on 92.3 Nigeria Info. We crossfire in the morning. Crossfire in the morning.
An application to stay execution of the order of the court to release those inmates, and also brought an application to set aside the judgment made by the court. We have responded to that affidavit by filing the counter affidavit allowed by the law. No, the court has the power to set aside its own judgment on certain grounds, fraud essentially, and on issue that the court does not have jurisdiction to hear the matter. Apart from that, we are not envisaging any other ground for the court to set the order.
This is the Morning Crossfire on 92.3 Nigeria Info.
Yes, indeed it is. My name is Sam Chinedu, the words and voice of Nasiru Ibiloye, a legal practitioner, of course, a lawyer to the inmates. In an interview with our correspondent, he explained the grounds the court can only set aside the judgment, which you just heard. And what we're talking about is River State setting aside the judgment of a high court releasing 150 prisoners from Port Harcourt Correctional Center. Now, time is a luxury we cannot afford. We're fast running out of it. I believe that the service that your organization provides is pro bono.
Yes, it is, absolutely.
Okay.
Yes.
Now, so it's, well, you might call it an act of goodwill.
Yes.
Whose duty is it to go to prisons and check for how many persons are waiting trial? Who has that duty?
Well, there's, according to Part 46 of the Administration of Criminal Justice Law, they have there's an establishment of Administration of Criminal Justice Monitoring Council, which is made up of the Chief Judge, who is the chairman, the Attorney General, a judge of the High Court, the Commissioner of Police or its representative, not below the rank of Assistant Commissioner of Police, the controller of prison in the state, the head of the National Human Rights Commission in the state, the chairman or representative of the state branch of the Nigeria Bar Association, the director of Legal Aid Council of Nigeria or public defender, a representative of the civil society working on human rights and access to justice or women's rights to be appointed by the council to serve for a period of 2 years only, the director of public prosecution. A member who is not a public officer may resign his appointment by a letter addressed to the chairman. Member of the council shall be paid allowance as applicable to state board and commissions and agency. Now, the responsibility of this council by Section 480 of the Administration of Criminal Justice Act is one, a speedy and smooth running of the administration of criminal justice, effective and efficient application of the law by the relevant agencies. The criminal matters are speedily dealt with. Congestion of criminal cases in court is drastically reduced. That the congestion in prison is reduced to its minimal. That the decision on the parole are speedily and effectively dealt with. That persons awaiting trial are not detained in prison custody.
Okay.
That the relationship among the organs charged with the responsibility of administration of criminal justice is cordial, and there exists maximum cooperation among the organs in the administration of criminal justice in the state.
So if you're fighting currently for 150 persons, that means that this council has not been doing their job.
Obviously. I've just told you what they are doing, what they are supposed to be doing, and the composition of the council. All the key players are in the council.
Does this council at this time exist in River State?
Well, on paper, it's here on paper. I don't know the composition of the council for now. But I know that the chief judge has visited the prison on several occasions and released some inmates.
All right.
But I'm yet to see it's on paper. I will say so, boldly.
All right, we're out of time. What do you hope comes out of this? What is the expected end for you?
Now, the Attorney General filed an appeal in the matter. We too filed a cross appeal. Our cross appeal is saying that this awaited trial who has waited up to this period, the court gave an award of 100,000 naira per each person.
100,000 naira?
100,000, yes, as compensation for them. We have gone to court and we're asking for 150 million. 1 million each for them. We are saying that what the court gave was inadequate. Ordinarily, we won't have challenged it if the people are released. I think it will be a console for them.
Yeah.
They'll go about their do their things in the society. We won't bother with that. But since they want to drag the matter, we are ready to go all out for them. And we know that we'll get justice at the end of the day.
Okay.
The Court of Appeal is there. The Supreme Court is there. We've got the justice in the High Court. We hope to get justice at the end of the day.
Thank you very much, Barrister Ibiloye, for your time.
Thank you.
We truly appreciate it.
Thank you very much.
Have a wonderful day.
Yes, thank you.
And thanks to you for being part of the Morning Crossfire. Of course, at 10 o'clock, the news happens, and Jude brings the midday dialogue. Connect with us on social media at Nigeria Info PH on all platforms. And with me, it's at Sparkling Oracle on all platforms. Have yourself a wonderful weekend.